It feels like deja vu, but never mind, we'll carry on and get it done. Could I remind everybody to turn their mobile phones off for one thing? And the other thing is, as I mentioned yesterday, if you're speaking to each other, the microphones, they're not that sensitive, but it was heard yesterday that things were being spoken in the background, so try not to say anything untoward, put it that way. Right, we start from where we left off yesterday, which is summing up, basically, which I hope won't take too long. Bearing in mind it is summing up, it's not putting the whole thing back out to us, it's summing up and giving us the highlight points. Could I start by asking members of the public that spoke yesterday if anyone wants to sum up? Just to put that point, not everything again, just put a point forward, or basically sum up. Anyone? None? Right, we'll go to the gentleman on my right here. If you by turn would like to sum up, I presume it'll be the usual firing order. Thank you.
I think it falls to me, sir, as I represent one of the residents. This may, of course, what I have to say, also no doubt impact on other residents in the locality. But of course, it's the residents that differ from the trade objectors, which the gentleman to my left represent, although a lot of what they said yesterday, I'm sure the residents would agree with. However, it is these people that are going to have to live and sleep if this application is granted, and the effects upon their life. And I would suggest to the committee what they should not have to do is put up with or cope with the ramifications of what this application is going to bring. And I will address that further when I come to various details. So, where does one start in relation to this? I would suggest it starts wholly and squarely with the application itself. You heard yesterday that this is to be a family-friendly premises, servicing the local community and providing facilities for, and I quote, locals in the main. It is claimed that the applicant has gone out of their way to be transparent. Well, bear with me whilst we just look at that, and there is a reason for doing so. The opening salvo from the applicants was an attack, I would suggest, on the objections by the residents themselves for what is described as deliberate dissemination of wrong information. It would appear, I would suggest, that they are attacking the very demographic upon which they seek to encourage into their premises, which one would suggest is a very odd thing to do. It is referred to that, as I've just said, there is various tittle-tattle, for want of a better phrase, within the village. But if the applicant does live in Ponteland, upon which there appears to be some doubt, he, I would suggest, should know that if you are not completely transparent and forthcoming with the information, you cannot then criticise those who are themselves critical because they do not know all the information. Indeed, those representing the trade objectors said to the committee yesterday that there has been some form of drip feed of information, and I'm afraid the applicants can't go behind that. This application has morphed as it has gone along. We've had the first set of plans, we've had the the second set of plans, we have had a note from the applicant. We've had an acoustic expert. And even now, at the hearing yesterday, further information has been supplied on various details. In some respect, they've launched a boat and are now busy trying to run around when there's a potential for it to sink, trying to mend the holes. And therefore one wonders why the village sit there and go, well, what on earth are you playing at? But why would I say this? Why does this become a factor for the licensing objectives? And I say this because how can you have faith in the applicant for promoting those objectives when they can't get their own house in order with regards to the application? I would suggest that there is very little faith, if any at all, by the way they've gone about this. It appears to have been poorly thought out at the beginning and not much better executed when it's come to it, because this is for a behemoth of an outside area supplying, amongst other things, alcohol and live entertainment. And therefore it's fair to say, I would suggest, that the main thrust of the residents' objections is going to be based around the licensing objective of public nuisance. Now, we have heard a lot about acoustics and otherwise, and there were some questions with regards to certainly the report that Mr. Walton commissioned, that it didn't really apply to him. Well, it has to be fair to say that he is not the closest resident geographically. But nonetheless, the clue is in the title, public nuisance. And therefore, I would suggest you are entitled to rely on that report, because members of the public, i.e. local residents, are going to be affected by what is going on. So where do we start with this public nuisance? Well, I would suggest we start by the lovely brochure that appears to have, well, has been disseminated, entitled The Orchard. And that was in the additional bundle of documents circulated. And at page 12, it talks about acoustics. And it says this: a full noise assessment was carried out by Douglas Doherty of Dax Limited that concluded, based on the design structure of the orchard and proposed noise mitigating proposals, confirmed the following. The calculated level of noise transmitted to houses during the operating period is below the levels recommended by the World Health Organization and PPG 24, and around 10 decibels below the average noise of current traffic as measured. On this basis, the noise from the venue can be considered inaudible. Well, let's look at that statement. Noise in relation to what is going to be happening at the orchard, I would suggest, can be divided simply into three. That is live music, background music, and the patrons themselves. So let's look at live music, because that is part of the application that is before the committee. Live music was not dealt with at all by Dr. Doherty in his report. No reference was made to it at all. Therefore, that is a bold statement within that brochure, and not, I would suggest, entirely accurate. That, I would suggest, would seem unusual, bearing in mind it forms part of the application. But as I've said previously, this application has morphed somewhat, because in the note that was written by the applicant himself, which appears twice, one of them at page 289, it says the following: "We have applied for live music as a licensed activity, but would not be hosting bands." So that's the first that anybody knows that there are going to be no bands involved. It then refers to the time and then says this: "will comprise of street-type entertainment." Well, what on earth is that? That could cover a multitude of things. And yet, again, here at the hearing, we discover it's going to be solo or duets, mainly guitar-based, playing around the tree that is marked on the plan. Nothing has been made clear previously in relation to that. So, you may say, where does that lead us? That leads you, I would suggest, to the report of Mr. Harvey Clark. Why? Because he is the only expert that deals with live music. It's as simple as that. Dr. Doherty predominantly agreed with Mr. Harvey Clark's conclusions. I accept he had a query with regard to the impact of booths and serveries in relation to the emanation of sound, but Mr. Harvey Clark dealt with that more than adequately, I would suggest. Also, before I comment on what the conclusions were, it must be borne in mind by the committee that everything is predicated on this 6-metre high barrier. So there is no alternative put before the committee saying, well, if this barrier wasn't there, we can still come within the noise inaudibility. There is nothing. That 6-metre barrier is part of the equation. Okay, well, Mr. Harvey Clark at his paragraph 10.6 did mention the fact of bands. Well, that appears now to have been removed, and therefore the little picture of the drummer, which Mr. Arnott clarified and confirmed that's what a drummer looked like, can be removed. But you will remember that when referring to even classical instruments, violins, flutes, and oboes, and even guitars, that they are very close, if not over, the so-called 80 decibel threshold. And you will remember, I would suggest, that in relation to live music, that Mr. Harvey Clark concluded, and this is at paragraph 11.4, that the levels would have to be so low to come in the audibility range as to be drowned out by patrons in any event. It almost, I think the phrase is used, it becomes meaningless. Well, if that is the case, common sense would therefore dictate that you're going to have to turn it up to be heard. Else why is a musician going to stand there and play music that can't be heard by anybody? There was a gentleman yesterday who plays in a band. Musicians do not like playing to people who can't hear them. What would be the point? Can you therefore, I would suggest, be confident that that is not going to happen? And it comes to the point I've made at the very beginning with regards to the lack of transparency. I would suggest that confidence is not high at all. Moving on to background music, and the same result occurs. the phrase ambient music was referenced. Gentle music as members of the public walk round the stalls. But again, it's going to have to be at such a low level to come within an audibility range as to be, again, meaningless. You're going to have to turn it up so people can actually hear this. And again, the same result is achieved. You turn it up, it ceases to become inaudible. Now, the applicant will no doubt say, as has been referenced yesterday at some length, well, hold on a minute, we've put forward a condition, that's condition 19 at page 37, as to an inaudibility at the nearest premises. Well, first of all, who drafted that? Whose suggestion was it? The police. Okay? The police, who are not acoustic experts. There's no evidence, I would suggest, in some regard as to the discussions that were occurring, bearing in mind this application is morphing as we go along. And also, as I'm about to reference, it would appear that the officer who did this didn't really have knowledge of what the High Court has said with regards to such conditions. My friend, Mr. Grunnett, on behalf of his client, raised the issue as to whether you can have a condition because of the fact is it a regulated activity or not. I'm not going to repeat that. But ultimately, I would suggest, whether it is or whether it is regulated, the High Court, and this is a matter of law, as has referenced by Mr. Holland in his submissions yesterday, and also in his objection on behalf of Daniela Holdings, and that's at page 140, that simply saying it has to be inaudible has been utterly trashed, to use a phrase, by the appellate courts as simply unworkable. So this safety net, this condition to protect the local residents, I'm afraid, is wholly and utterly unworkable. And the policing of such is fraught with difficulties because inaudibility is subjective. Someone standing at the boundary of the nearest property might hear something and be annoyed, somebody else might not. So again, it's just unworkable. And again, I would suggest, simply lacks any forethought and reflection and simply relies on the police's suggestion. And that, I would also counter, leads me nicely on to the issue of the third area, and that is in relation to patrons themselves attending this area. There is no condition in relation to patrons being inaudible. It only relates to live and recorded music. Here, I would suggest, the applicant tries to mitigate the impact by saying, well, numbers aren't really important in a way. And Mr. Doherty, in his report at page 5, produces what I'm going to suggest is perhaps an unrealistic figure in relation to people attending, certainly later on in the evening, where he says this: towards the end of opening, the operator suggested, based on their local experience, there may be as many 150 in the premises, and maybe 20 being very loud. Okay. Well, that, I would suggest, is fanciful for the following reasons. Mr. Holland made a number of good points, but I'm going to pick one of those. And that is, this is a commercial operation. It's plain and simple. It is a money-making business. And that's not a criticism, that's an observation. It's quite clear that people are investing in this, and you don't invest in anything unless you're going to get A, your money back, and B, make a profit. That is the capitalist society upon which we live in. The way you make profit in this is feet through the door. It's plain and simple. The amount of people that can come in, spend their money, and then leave. I lost count how many times Mr. Arnott, and this isn't a criticism of him, said, "We do not believe this will fail." Again, understandable, because you're not going to invest in the business you think is going to fail. It's just, that would be common sense out the window. But if it's not going to fail, and they have confidence that it's not going to fail, they're going to be confident in the amount of numbers that are going to be coming into that premises to spend that money. And that cannot be predicated solely on the retail outlets that they are providing, however quaint and nice they are. The reason being is, what person at 9:30 is going to want to buy some artisan loaf or shop for some sweets? That, I would suggest, is unrealistic, even from a common sense perspective. But let's look at how this premises is designed. It's capped at 350. There are 152 seats. That means at full capacity there are 198 people standing. Standing doing what? Doing what? I tell you what they're doing. They're going to be drinking when the evening comes in. Because alcohol and the markup of alcohol is profitable. Because if it isn't, this application wouldn't be for the committee. It's as simple as that. They would just be constructing a retail park. But no, we have alcohol involved. And I would suggest that there is one very telling point in relation to this. And this came about when there was a substantial volte-face in the applicant's case. Mr. Arnott, when he made his presentation, said there will be no screens. Plain and simple, that's what he said. When Mr. Holliday decided to speak about the issue when he was asked questions, certainly with the upcoming World Cup next year in Qatar, I will deal with that when we come to it. Then, when asked about conditions, Mr. Arnott said, no, we will not be offering a condition that there will be no screens. Why? Because it's plain and simple, and everybody in this room knows that when there is a big sporting event on, it's screened. Why? Because it attracts people. Why? So they can be outside having a drink, watching it. It's as simple as that. It doesn't require you to be a rocket scientist to work that one out. That, I would suggest, is not family friendly. What family are going to take their children into this area when there are potentially hundreds of football fans drinking and watching a game? That again is common sense out the window. Are you going to tell me this is going to be local based? Well, if the locals aren't coming because they've been criticised, you've got to advertise wider if you're going to make a profit. And then, what happens if your team scores? And I will refrain from any jokes about England scoring in the World Cup. But we've seen on telly the reactions in these drinking parks. BBC, Sky, ITV, the whole place just erupts. Beer gets thrown everywhere and people, understandably, leap up and down. That is going to blow the acoustics out the window because Mr. Harvey Clark deals with that. 79 decibels, one person talking very loudly. Now times that. Now increase it substantially. Is that going to be inaudible at the nearest residential premises? Well, there's no condition. And it comes back to the point I made. It's not for these residents to put up with that. Because the applicant quite clearly is playing their cards close to their chest and seeking this as an option to make a profit. And Mr. Harvey Clark comments on this in his report at 11.5. Even with a 6-metre noise barrier, the noise from patrons within a 350 capacity outdoor drinking area is considered to constitute a perceptible change to the existing acoustic environment, which may have a detrimental effect on the quality of life of the surrounding residents. I don't understand what can be clearer than that. And Mr. Arnott, and I think I need to address this point, said, well, Mr. Harvey Clark's report is not objective because he's been instructed by Mr. Walton, who is a resident. Well, whether that is or whether that isn't, the same can be levelled at Dr. Doherty. But what Mr. Arnott, I would suggest, can't get away from, is the fact that Dr. Doherty predominantly agreed with Mr. Harvey Clark, subject to the query which I would suggest was answered. So when you have that statement in the brochure supplied, that doesn't cover everything. There's no live music, and I would suggest is technically wrong because it's subject to so many conditions as to be wholly and utterly unworkable. You then have patrons leaving the premises. And you've heard Mr. Holland address this. At the moment, the only exit is that out by the Seven Sisters. Newcastle playing a home game, which they are this evening against Leeds. Can you imagine that on a Friday night with loads of supporters kicking out at 10 o'clock or so, or even later, having all drunk onto the street? Because, of course, the applicant says the vast majority will be coming by foot. That will require transport, because they certainly won't be driving. And even if you look at car parking spaces, at the moment I understand there are 13, with another 23 potentially in the making. That's 36. If you have 4 people per vehicle, that's 144 people. That leaves 206 on foot, looking for transportation home, parked elsewhere, disrupting, I would suggest, potentially the local residents. Therefore, when you stand back and you assess all the evidence that is before you, I would urge you to take the following course. Mr. Walton makes reference in his objection, starting at page 273, to Northumbria County Council's own licensing policy. At paragraph 26, he comments at the paragraph for the local council 3.1.6, where the Licensing Act 2003 also supports a number of complementary aims which are integral to the policy. Protecting the public and local residents from crime, antisocial behaviour and noise nuisance caused by irresponsible licensed premises. Over the page at paragraph 27, moving on to paragraph 6.8.2, when considering any representations, the licensing authority will assess the likelihood of it causing unacceptable adverse impact, particularly, not including, particularly on local residents. And given the information before the committee, I would suggest there cannot be any doubt in the committee's mind that what is proposed, how it's proposed, and how it's meant to work can only and utterly impact adversely on local residents. The condition that has been mooted so many times does not, I would suggest, save the applicant in any way, shape or form. It's too many holes in it, and it certainly, as I said, doesn't deal with patrons. And therefore, this application simply for this site needs to be refused. Thank you.
Thank you. Right, gentlemen, that was a very comprehensive summing up. I hope you won't repeat things that have been said because we've already heard them once. So if you would like to sum up, possibly shorter than that if you could, but please do.
Mine is going to be shorter because my presentation was long, but the points are similar in ways, but I will be not delaying you unduly, Mr. Arnott will be, I'm sure, speaking to you in a matter of moments.
Thank you.
This is an application that could have literally been drawn on the back of a fag packet, the lack of detail in it. For such a huge application, that's simply not acceptable. The notes and the hasty amendments that have been coming out even during the course of the presentation are thin and superficial attempts to persuade the committee that those issues raised by the residents and trade objectors can and will be dealt with. But these are not issues that are novel in nature or were unforeseeable. These are matters that the applicant should have considered in their application and set their case out. By setting out their case, it could have been properly examined and the facts behind it and the likelihood more accurately gauged. I believe that the way the application has been put has been done intentionally to deny that opportunity. And the way that the application keeps moving and flowing is a sign that the applicant is ducking and diving and trying simply to say things to appease what they think the committee want to hear, and they do not reflect the true intentions. The principal one is that this will be a family venue and no discussion of any other type of operation or customer is mentioned. That is simply unbelievable. It's not realistic. And as a committee, an experienced committee, you know that is the case. You know there will be other trading periods at 10 o'clock, 9 o'clock on a Friday and Saturday evening. It is not going to be a family venue. The principal licensing objectives that we've discussed most over the last 2 days, I feel, is public nuisance and crime and disorder. So on the issue of public nuisance, you heard evidence from 2 consultants who were generally in agreement about the difficulties of this site. And both were in agreement that crowd noise could potentially have a negative impact on the local environment. That was accepted by both. The applicant's calculations were based on occupancy of 130 from a potential occupancy of 350 for the site, which we feel is artificially low. It was telling that nobody would put their name to that figure. The expert wasn't having it. The applicant wasn't having it. nobody could really put their hands up and say where that figure came from. That's typical of the application, I say, and Mr Halliday's strange revelry in not conducting any market research or having any evidence support any of his propositions. It was bizarre, other than the fact that two other trade objectors with equal or lengthy experience are taking contrary views. He's not taken the opportunity, since those representations have been put into, to bring any meaningful evidence. There is no evidence before the committee about the type of operation that we'll have and the customers. There will be a noise arising from dispersal at the end of the evening. That will be a potentially large number, up to 350 people, exiting this site at as late as 11:30 p.m. on a Friday and Saturday into the centre of Pontyland and around. That will, again, cause a noise nuisance directly arising from the activities of this site. One of the residents yesterday did mention and put forward an argument about cumulative impact. And, Chair, I noted that you highlighted there wasn't a cumulative impact policy in place in Pontyland at the moment. That is entirely correct, but it is established that the committee are entitled to consider whether cumulative impact does arise from an application, even if there isn't a policy. It does not reverse burden of proof. It's not the same as a policy. But such a huge change in an environment like this, it's not unforeseeable that there will have cumulative impact effects. So it is not the decisive point, but it is something to be weighed, and you will give it appropriate weight, I'm sure, in your decision. It may be more or less than I hope. The conditions. This is a point that I've raised and I'm sticking strongly to. The activity of live and recorded music before 11 p.m. for audiences of less than 500 persons is not regulated. It's a simple, that is how it is no longer regulated. You cannot regulate it. That means you cannot condition it. It is not a regulated activity. And the condition from Mr Cochrane, who's an excellent police officer, is the origin of that condition. It is no way can that be seen to be great evidence or a legal opinion that that condition is enforceable. It is nothing more than an intention, and we have a concern that if that condition was put on its current format, when the rubber hit the road, as the lawyers would be entitled to argue in the face of prosecution, that it can't be enforced against them. There is no way to waive that situation, save for a licensing review instigated after the grant of a licence in light of a nuisance arising by your EHOs under a very specific part of the Act. That disapplies the deregulation, makes it regulated, but that is not a power before the committee. It's not something that an applicant can volunteer. I have looked very closely at this for clients on several occasions. I accept that the Live Music Act is therefore permissive, but each case must be considered on its own merits. And 350, although below the 500 threshold, is huge in this context, in this area. And you have a right to take that into account. It is telling, I think, that the applicant has not bolstered any of the conditions. They've distanced themselves somewhat from the conditions by saying, this is what the police wanted, that's what we're doing. They're not going to engage a single step further than what they've been told they have to do to avoid a police objection. That's as far as they're going. They're not going a step further. And I think it's telling, as Mr Kemp pointed out, that noise arising from, foreseeably from their customers, acting rowdy in the evening, they have not offered a condition limiting that or to control that. The only condition offered is, in my opinion, unenforceable. And I'm surprised that that was not discovered and identified and addressed at an earlier stage. The second issue is crime disorder. I am coming to the end, sir. The applicant wants you to feel this is a benign, family-friendly site. That's all it is. Nothing to see here. Move along. It's not going to be a problem or vertical drinking or those terrible issues that you can. But Mr Holliday confirmed that he had no market research at all to support that. Mr Halliday has expressed views as the chair of the Pub Watch about concerns of new developments bring other people into the village other than residents that might be less than savoury into that environment. They have indicated that there will be a greeter on the door to rebuff non-desirables, I think is the way that Mr Arnott described them. Everybody knows that this is going to bring in new elements to the village. It's going to bring additional people into the village centre that weren't otherwise there. And as Mr. Detail explained, that's a necessity for the success of the business. And to deny that, I think, is simply not plausible. Instead of saying, yes, there will be, and this will be how we will deal with them, is the correct approach. Telling this committee it isn't going to happen, it's just not plausible. And it is contradicted by things that the applicant has said, or we'll have something to rebuff those elements that come. So it's not happening, but we are going to have a greeter to rebuff them who's SIA registered. My client, and I think it's a view shared by Mr Holland's client and by many of the residents here today, is that this is not going to be exclusively a family-friendly venue. And if that's all it was going to be, you wouldn't face the enormous amount of objections that you've received. My client, who's an experienced operator, and Mr Holland's client, in his representation, explained, expressed to you that on especially Friday and Saturday evenings, this is going to become another vertical drinking venue with a capacity of 350 as established now in the centre of Ponteland. That's what we think. That's what most of the residents, if not all, think. What do you think it's going to be on a Friday and Saturday night, if not that? Which is more plausible? Let me point out, absolutely no evidence put before you other than Mr Halliday's view. Well, we're giving you another view of equal experience, which seems to be shared by most of the people in the room. Mr Arnott pointed out this is not a popularity vote or a poll of numbers. Maybe I could suggest a vote that we do it that way this morning. I think we'd win on that basis, but maybe we're not going to go there. But it's a huge number of common sense approach will seize the impact of this application, which the applicant, in either a blinkered way or entirely naively, ignores. Now, I don't think that Mr Halliday is naive. I don't believe he can truly believe that there aren't going to be issues of vertical drinking and a different crowd on a Friday and Saturday night, and they haven't addressed it. When you retire, there are some very simple things I'd like you to do. Obviously, you'll take advice from your legal advisor. You'll consider all of the evidence. Imagine living in one of those houses near this site. If you heard about this application, taking on board all of your years of experience of just living, is this site for 350 people a stone's throw from you going to cause you a noise nuisance? It absolutely is. You know the answer, and everybody else, apart from the applicants in this room, know the answer to that. It is going to be a noise nuisance, and that is obvious. This application is simply not good enough to address the serious issues of this application, and the applicant has refused, by their own actions, to engage properly on those matters. This is an application which is disrespectful to the residents, and it's disrespectful to the committee. I think the committee has a right to have these issues fully and properly explored in front of them, with proper plans and proper policies put in front of you of how these issues were going to be attended to. This is simply far too great a risk. I asked you yesterday about specific conditions to make sure that if you grant it about this site, my client's instructions are still that we would prefer a refusal, because at the moment there are so many unknowns, so many holes, and until the applicant can grow up and accept that there are going to be issues on a Friday and Saturday evening about the site that need properly addressing before the committee, not denying that they will exist, not denying it will fail, not just saying my experience tells me this. We can see the potential issues which are obvious to everybody, and this is how we propose to address them. It is not correct for this application to go through, and the committee are well within your rights to say, at this stage, there are too many issues unresolved which lead us to believe this is going to, or we're not satisfied, this is not going to undermine the licensing objectives, and that is a duty entirely on the applicant. It has been a long day and a bit. Thank you very much for all of your attention, and we would urge you simply to reject this application at this stage. Thank you.
Thank you very much. And finally, well, not finally, but for the objectors.
Because Mr. Arnott has the last word, Chair, I'm going to try and be very brief.
We would really appreciate that.
Essentially echoing the summing up of Mr. Grunnett, which the point I particularly press upon you is the risk of granting in haste and repenting at leisure in this case. The promotion of the licensing objectives on the applicant's own case hinges upon the erection of half a square kilometre of living wall fence, a suggestion that came yesterday in its latest format. That is a matter that there should have been explicit consultation on from the outset. I'm very well aware that you're alive to the distinction between planning and licensing, but that there is an overlap on the issues between the two. The guidance suggests liaison between the two regimes, and I can give you an example. When I went and applied for a licence for stack at the bottom of Northumberland Street, at the request of the licensing authority, the hearing was adjourned because they wanted to know what the planners thought first, and that was an example of an application where planning and licensing and all the other consents were sought at the same time, and we had an overarching and detailed plan as to how we were going forward with all our stakeholders on board. This is a smaller operation than stack at the bottom of Northumberland Street, but in its context it is as important for the people of Ponteland as stack was for the users of the city centre of Newcastle upon Tyne, if not more so. Its size, its location, the site's nature, particularly its open air character, the access ways in and out, the demographic, something with that much standing capacity is likely to attract. All of those matters have got very great potential for harming the licensing objectives, and indeed for starting the sort of domino effect we've seen in other areas like Osborne Road. And to adopt Mr. Kemp's analogy of launching the ship, you need to be absolutely sure in my submission that the ship is going to sail in the destination that the captain and his pilot have been telling us yesterday. I'm afraid there are too many unexplained gaps in the superstructure, in the blueprints. You are entitled to say, and I urge you to say, go away and come back with a proper scheme that has been truly transparent, has properly been consulted on, the joined-up government that the Section 182 guidance urges on you has happened. And so not just us, but locals and local businesses and local residents can have confidence in. Because at the minute, I'm afraid, the application just raises too many unanswered questions in my submission for you to be saying you can have this licence and other things can be worried about later on down the line. In my submission, that's an abrogation of responsibility on behalf of the committee. You need to be confident and sure that this scheme is going to work in the way that it has been described, and I don't think I would urge that on what you've heard you can't reach that level of confidence. So that's my work closing and summary.
Thank you. Now, the applicants. You know my feeling about death by solicitors, man.
I do. I usually make.
I respect your. You've got to put your case forward.
No, Chair. I always make. I have one joke, and that is that we get paid by the hour, so I'll take as long as I possibly can. But
I'm trying to save everybody money.
yeah, I know. But
Except yourselves.
But reading the body language, I will be mercifully brief. I do want to make one point, though. We've had a reasonably well-natured hearing, and that's a compliment to you and everybody else, but we do take some exception to Mr Grunett's comment there that we over here need to grow up. I think that was really unnecessary, and perhaps he'll reflect on that. But anyway, the headline in the Chronicle last night, we made the Chronicle, was licensing hearing rocked by claims of mudslinging. So I don't know whether you were rocked by what you heard yesterday, but it is worth reflecting on what my colleagues over there are here to do. And that's to convince you that what my colleagues want to do will be awful. That's their job. And I don't criticise them for that. I often am in the same position that they are. Mr Holland referred to us as taxis, I think. That was, yeah, I prefer gunslingers, but taxis anyway. And we represent a client to the best of our ability. And when you are representing an objector, your job is to make the application look as awful as it possibly can be. And that's what they've done yesterday, and that's what they've done today. But your experience, you know that, and you'll see through that. So I'm not going to dwell on that, but I think it is a really important point. Mr Holland talked about, well, we've not really given you enough information. And I would suggest that even if we did as he suggests, which was to come back with another application, they wouldn't be satisfied. We come back with a third one, they still wouldn't be satisfied. They will never be satisfied because it's their job not to be satisfied. It is not in their interests to be satisfied with our application. But again, you'll understand that. It's obvious, surely, from everything that you heard yesterday, that the proposal is not involving a container park, a festival site, or a beer keller. Can we put that to one side? That is not what we intend doing. We have been entirely transparent, entirely, from the outset. We've been criticised for a lack of consultation, but that simply isn't true. You heard yesterday about a meeting in May, local authority, planning didn't turn up, fire, environmental health, police. We explained the proposal to them there, all of them, and they engaged with us. That's how we ended up with the conditions. We had a second meeting in July. Same people involved. Again, same process. So to suggest that we're playing our cards close to our chest just simply isn't true. We have been transparent throughout. And all we want to do is to create this. And that's what we've described to you yesterday. Not this awful place that my friends over there would have you believe you would end up if you kindly granted the licence to us today. It will be a family-friendly venue. It will have lots of different types of activities going on in it. It will be a positive addition to the Ponteland. Now, Mr Holland says that it will be inevitably wet-led, a vertical drinking venue. That simply is not borne out by what we've described to you. He wants you to believe that, but again, I'm sure you will not. If that was our intention, and that you think that everything that we said yesterday was untrue, we wouldn't be doing what we're doing because we have all of those retail units. 10 retail units. Now, it's suggested that the only way that we're going to make money is selling alcohol. That's not true. We will have rent from those units. We'll have rent from the shops. We'll have rent from the market stalls. That will be generating income. There will be food being sold. That generates income. And in fact, the sale of food, in terms of margin, makes more than drink. And we know that. Experienced operators will know that. So for those reasons alone, I think you could start drifting away from their particular vision of what it is we'll be providing to you. Equally, if it is that we wanted to provide this beer keller sort of scenario that they're describing, we wouldn't have applied for the hours that we have. Just remind ourselves of what it is. Recorded music to end at 10:30. Alcohol 10:30 on a Sunday to a Thursday, Friday and Saturday, 11 o'clock. If we were after that sort of crowd travelling up from Newcastle, we wouldn't have applied for those hours. They're not going to be interested in that. That's not for them. This is not the sort of venue that is going to have any attraction to them. We've also been criticised for a lack of market research. We don't need market research. We don't need to pay a researcher to tell us what we already know. And the reason that we know that this will work in the way in which we've described it is that we've traded in Ponteland for decades. We understand the place. We understand how it works, how hospitality in the village works. We don't need to go to somebody else to tell us that. We're also criticised, very unfairly, I think, for making changes or proposing changes to our application. I agree entirely that our application has developed over time, but it's become better. And again, that's not something that we'd be criticised for. That's not a bad thing. We've also been criticised, as I've said, for a lack of engagement. But again, we have been transparent, particularly with the responsible authorities. Perhaps with hindsight, we'd have engaged with the locals in a different way. But my friend Mr. Kemp says that we're criticising our local residents, that we've alienated them because we're saying that they just don't understand. And that's not what I've done. What I've done is criticise those who deliberately spread misinformation about our application, upon which residents, I think, have acted. But hopefully now that this has all been explained in detail to you, you'll understand that what we want to do is not what they suggest that we want to do. We have done, I think, everything that we possibly can to get the information out there. There are no gaps in our application. Our application is comprehensive, and we've explained it to you in great detail yesterday. I can't imagine that there is anything about this that you don't understand or that you need further information on. What's very significant, though, is that we have no objection from the police. Now, the police, as you know, are your main resource for all matters relating to crime and disorder. They do not object, and they have been engaging with us, and they've been discussing this with us since May. So there's nothing about this that they don't know, but they don't object. Equally, also significant, environmental health don't object. They too have been involved in the engagement, the consultation. They are not concerned about what it is that we propose doing. If it were otherwise, they would be objecting, because that's their job. Now, there's been criticism of the condition inaudibility and of Steve Cochrane, you know, he's not qualified, etc., etc. He's not here to defend himself, but in any event, we are happy for that condition to be imposed on our licence if you kindly grant it to us. If you're uncomfortable with that condition, because of the word inaudibility, it may well be that you would look at an alternative version of that condition to give yourselves comfort. We're happy with that. It may well be that you would look at a condition to the words to the effect that no noise associated with the premises shall exceed a level of to be agreed with environmental health. We'd be happy with that. That would achieve the same aim. And dealing with Mr. Grunett's point about whether these conditions are enforceable, I disagree with him. You have a discretion to impose any condition that you feel is appropriate to the promotion of the licensing objectives. And I am more than happy for you to impose such a condition on this licence. But another significant point, and we'll be criticised for this, I'm sure, but having discussed the way forward this morning, my clients are more than happy to forgo live music, if that again gives you some comfort, in addition to the condition that we proposed yesterday of a capacity of 350. We don't think, unlike our friends over there, that we will be trading to that capacity. It may happen occasionally, but it will not happen regularly as they would suggest that it will do. That simply won't happen. We're not providing this beer killer type environment. We have fulfilled our obligations under the guidance, and the guidance says that we are expected to include positive proposals in our application as to how we will manage any potential risks. We're aware of the risks. The conditions proposed by the police, which we've agreed to, are voluminous. There's nothing in that schedule, there's nothing missing from that schedule that you would expect to see. It's there, it's all there. Now, we are at a very early stage of this proposal. But we think, hand on heart, that bearing in mind what we've explained to you, we've jumped over the hurdle. And you can justify to yourselves granting the application. Planning comes next. We're a long way off, I say. But so far as licensing is concerned, we have fulfilled our obligation. We've explained the application in great detail. We're aware of the risks, and we've told you how we will manage those risks. So, Sir, Chair, members of the committee, I'm conscious of time. I'm not going to take up any more of yours unless there are any specific questions you have of me or my clients. That's the end of our application.
Thank you very much. It would be unfair to start and ask questions again, bring up yesterday.
Chair, could I just ask a couple of points of clarification with the applicant just before we retire? Is that okay?
Yeah.
Thank you. Can I just clarify from what you've just said that your client is happy to forgo the application for live music? Are you asking for that to be removed?
Yes, delete that.
Delete live music. Thank you. Just a couple of other things. The only other condition that you were offering up is the 350 limit on the capacity to the external area.
That's correct, yeah. Did you want that marked on a plan?
I think if the committee were minded to grant it, I think we could do that. And also, can I just clarify, I think you said in respect of Rialto yesterday that there were 120 covers. Can you confirm what the capacity of Rialto is? Because that's different to covers.
Well, it trades as a restaurant. I mean, 120 covers is what it has. I don't know for fire purposes what the capacity is. I took the liberty of looking on Rialto's website, and I think it said it had a capacity of 200. I think 100 in a function room as well. 120, I'm being told, yeah.
So the capacity isn't 200?
No.
It's 120?
Yes.
So if everyone was sitting down, there wouldn't be anyone else in the... No. Right.
It's a restaurant. People wouldn't be milling around.
Okay, thank you.
I know Mr. Arnott summed up, but as the applicants, have you anything else to say, to put forward? Or has he done it adequately well? It's only fair that you get the chance. Okay. Right, we will retire and make a decision on this. It's going to be a tricky one. Well, it is. They're all tricky. There's going to be somebody upset at the end of the day. It'll either be the applicants or the objectors. And you all have the right to appeal within 5 days. One of you will, sorry? 21 days, why the 5? 21 days. I would imagine there will be an appeal from one side or the other, but we'll do our best for both parties. It is tricky, but we will try and do our best. Thank you very much for attending, and we will, the decision will come out within 5 days. That was the 5 days bit, yeah. Right, thank you very much.
Can I just confirm that's 5 working days, and it will detail any right of appeal that anyone would have?
Okay, thank you.